Ms. Jones, is there anything you'd like to say before I sentence you?
Yeah, I need help. They said they would get me help at inpatient for drug treatment.
Ms. Tranter?
My understanding, Your Honor, is that Ms. Jones is prepared to change her plea to guilty as charged for a grand theft felony of the 4th degree.
Mr. Newberger, is that accurate?
Yes.
All right, Ms. Jones, they're telling me that you're going to change your plea to guilty to the theft charge. Before we get to your change of plea, I am required to go over some things with you. Do you understand that?
Yes, sir.
How old are you?
31.
How far did you go in school?
12th grade.
Can you read and write?
Yes,
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Newberger?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me, it's called a change of plea. On the second page of this document, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
You feel like you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to a theft charge, a felony of the 4th degree that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means that if you are sent to prison on this charge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that? But as I've said, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. If you violate those rules of community control, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty, and their verdict must be unanimous. Do you understand that? At that trial, you have a right to see and hear all the evidence that the state has against you with the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of the charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that? Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
Ms. Tranter.
Your Honor, in addition to the facts alleged in the indictment, this incident occurred during a time frame of April 25th through June 12th of 2025, Warren County, State of Ohio. Defendant was a manager for the Deerfield Walmart store during that time. She was observed accessing the store's deposit box, using her code and grabbing money from the safe and putting it in her pockets and sleeves. Total loss to the store was $80,617.
Mr. Newberger, anything on those facts?
No.
Ms. Jones, did you hear the statement that she read?
Yes, sir.
Did you admit and acknowledge that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, those rights we discussed?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we have discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Ms. Tranter, anything before I sentence her?
Nothing further, Your Honor.
Anything from probation?
Nothing further, Your
Mr.
Honor.
Newberger?
No.
Ms. Jones, is there anything you'd like to say before I sentence you?
Yeah. I need help. They said they would get me help at inpatient for drug treatment.
Okay. Ms. Jones, what is your plan? This case has been pending for some time now. What is your plan to pay off this obligation that you now have?
Get a job and pay it back.
$80,000. I mean, if I put you on supervision for a period of 5 years, $80,000 divided by 60, I'm guessing it's going to be about $3,000 some dollars a month, if my math is correct. And how are you going to pay that back?
Get a job or two.
Okay. All right. The court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. I am going to find today that you are amenable to community control, so I'm going to place you into community control for a period of 5 years. You will be subject to the supervision of the Warren County Probation Department. Refrain from the use of any drugs, illegal drugs, alcohol, or marijuana. You are not permitted to use marijuana in any form. Do you understand me?
Yes, sir.
There's restitution owed of $80,617 to Walmart. You are trespassed from all Walmart stores. You're not permitted to go into Walmart anymore. You understand that?
Yes, sir.
I'm ordering you to serve 180 days in the Warren County Jail. You have credit for the 5 days you've already served. You are also, I'm going to find that you're indigent for the purpose of any fines, costs, or other financial sanctions, because I want this restitution paid. Now, you're also subject to a discretionary period of post-release control, which I just spoke about. Do you want me to go over that with you again?
Yes, sir.
All right. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Now, I am remanding you into the custody of the Warren County Sheriff to begin serving your jail time. I'm going to have your probation officer looking into some sort of inpatient treatment. Now, if she arranges something, I will suspend further execution of the jail time while you are going through that treatment. You will be placed on a monitor while you're in that treatment, and then at the end of that treatment, I will determine at that time whether I will further suspend the 180 days. So you owe right now 175 days of jail, and I'm telling you right now, if you're going to go through the treatment, you're going to go back to the jail. I'll determine then whether I'm going to make you serve the rest of the days. But if you don't have a solid plan in place for this restitution, if the restitution is not going to get paid, most likely just going to be sent to prison and serve out your sentence there. Do you understand me?
Yes, sir.
Do you have any questions for me?
No, sir.
Are you pregnant?
No, sir.
All right, this time there's the Warren County standing behind you. I'm remanding you into his custody to begin serving your sentence, and you'll let me know about the treatment, right?
Yes, Your Honor.
Okay.
One question, Your Honor.
Yes, sir.
If treatment becomes available, will the court, it's a lot to ask, but will the court absorb the cost of the GPS because she's got $80,000 to pay and she's got issues with other places?
I'll talk with the probation officer about that.
Thank you.
175 is what she owes. There's going to have to be an amended.
Yes, I'll just do 175 and somebody.
Yeah.
Thank you.
Thank you.
The judge gives community control, jail time, and a chance at treatment, but warns mispayments and prison is waiting. Was this fair or too lenient? Comment below. And follow for more real courtroom moments.